Yes.
What about in the area of civil law? Any decision that come to mind?
In the area of civil law?
Yes.
Must it be from the Supreme Court, my lady?
Supreme Court, yes.
Okay.
We are confining ourselves to this Supreme Court.
All right. No, I can't recall any.
All right. The Njonjo Mue case, does it ring a bell?
Yes, it does. It does.
What did the Supreme Court say in that matter?
The Supreme Court held that because there was a breach of privacy of the litigant, then the court needed to frown upon parties taking shortcuts in respect to obtaining evidence.
So that I've given you one case, another one?
I cannot recall.
What is famously known as the SGR case? The SGR case, Kenya Railways Corporation versus Okiya Omtatah and others.
No, that doesn't come to me.
It doesn't ring a bell.
Yes.
So in your own view, this question of whether evidence is admissible being pegged on how it was obtained, do you think that that is a fair state of affairs?
One of the considerations that I would give as a judge confronted with that question is the nature of dispute and the impact of the evidence that has been shut out. If the dispute that is before me is one that involves as well the rights of other people in terms of fundamental breach, and the infringement can be redressed or remedied in another forum, then I think there would be a question of balancing. Has the evidence that has been shut out, what impact does it have on arriving at a fair decision in the matter that is before me as a judge?
All right, Judge, I hear you. But let's take the matter of Kenya Railways Corporation versus Okiya Omtatah, the SGR matter.
Yes.
Where documents had been tabled before committees of parliament. And this, of course, involved the construction of the railway, and it was a matter of public concern. And the Supreme Court did say this evidence was obtained irregularly, hence not admissible. So given what you're telling us, the considerations that you are saying you'd have to put into effect as you're considering this matter, so given that kind of scenario, where there are documents that have been tabled before these committees, it's a question of construction of the Kenya Railways, and it's a matter of public interest. Would you then still say that how this evidence was obtained would come into bear in the decision that you would be making?
In respect to that scenario, I would have to consider that there is the access to information provisions. And so one would need to weigh what was the circumstances. Did the person who obtained this evidence attempt to utilize the lawful avenues available by the law, by the legal framework, to actually obtain that information? I do not know the factual metrics of the matter that you cite, but one question that I would be asking is, why did the petitioner, if it was public documents, never utilize the access to information provision of the Constitution, which is now statutorily embedded?
All right, we leave that issue, but of course the question here, you seem to be saying that as far as you're concerned, the main consideration would be we would be departing from what used to obtain before the 2010 Constitution, and we would have to focus on how the evidence was obtained.
Yes.
That's what you're saying. Now, let's move to another area, and the area of loci standi. What was the position before the 2010 Constitution?
On loci standi generally, or in respect to what area?
Generally.
Generally.
Yes.
Now,